On June 26th of this year, it issued its opinion in the case of Windsor versus United States, ruling that Section 3 of the Defense of Marriage Act, DOMA, D-O-M-A, is unconstitutional. So my first question to you is, please explain the background of this case to our audience.
Great, absolutely. And before I start, I just wanted to say thank you to Raphael for organizing this, to Dr. Houlihan for organizing it, Dr. Salholz for inviting me, and to my wife Jennifer Wingate, Dr. Wingate, for introducing me to Dr. Salholz. So I'm a little worried that the lighting's a little bit dim in the room. Nobody fall asleep, even though we're talking about tax.
Well, I like it dim.
Okay, that's fine. Then dim is good, but no falling asleep. All right. So, in a sense, what we have is it's kind of unfortunate in a way. We're going from the sublime to the ridiculous, in a sense, with what we're talking about here. And I'm just going to read a paragraph to you. It's not really a paragraph. It's not really prose, but I'll just read this to you. Kennedy delivered the opinion of the court in which Ginsburg, Breyer, Sotomayor, and Kagan joined. Roberts filed a dissenting opinion. Scalia filed a dissenting opinion in which Thomas joined, and in which Roberts joined as to Part 1. Alito filed a dissenting opinion in which Thomas joined as to Parts 2 and 3. All right, so we had the story of this wonderful married couple who the court decided ultimately were entitled to a certain federal benefit. And the court's opinion in June is this complicated. This is just telling you who wrote what parts of the opinion. It's not even getting to what the opinion said, but that's just how complicated it is. And it's also important to note that what the opinion didn't say. So the opinion didn't, neither opinion, we're talking about two opinions today, neither opinion said that same-sex marriage is legal, right? Neither one said anything remotely like that. Even though that may seem, there's certainly good news here for same-sex couples, but there was nothing along those lines. The case really turned on a concept called standing. Has anybody heard the phrase, the term standing?
Hi, students. We did.
Right. So standing. What this means is in federal court, in order to be heard by the court, in order for the court to reach the merits of your case to decide whether you're right or wrong, the other guys are right or wrong, you have to have what's called standing. There has to be an active case or controversy for the court to decide. You can't just have an important question of law. You have to be somebody who's directly affected by what's happening. It can't be your generalized interest as a citizen, even if you believe that this is something, a law that is unjust or unconstitutional. You can't challenge it unless it affects you directly. So in a way, both cases, both Hollingsworth v. Perry and the Windsor case, are all about standing, which is why I say we're going from the sublime to the ridiculous, because both the cases really turn on the question of whether the court has the right to decide the case. That's really what drove the outcome in both of the cases we'll be talking about today. Specifically in the Windsor case, what happened, Windsor filed her estate tax return after, or her partner filed her partner's estate tax return after her partner passed away, and claimed a federal exclusion. So when married couples, one member of a married couple dies and leaves her estate to the other couple, if they're truly married for federal tax law purposes, there's no tax at that point. When they then leave, the second partner dies, then they leave the estate to children or somebody else, then the estate tax is imposed. But on that intra-spouse transfer, there's no tax. The IRS denied that claim for the exclusion on the basis of the DOMA provision, Section 3, that said marriage is a union between one man and one woman and nobody else. Right. So the question in Windsor was whether that provision in federal law, simply saying that for federal purposes, tax and otherwise, you have to have one man and one woman for it to be recognized to get the benefit of that state tax provision. But there was a problem. Nobody, and this is true in both cases, nobody in the government wanted to defend the constitutionality of this anti-same-sex marriage provision. Certainly nobody in Obama's executive branch was excited to get up and defend this provision. So there's a problem, right? You can't challenge, you can't go to court unless you have somebody who is directly affected by it, not in a generalized way, but in a specific way, who's willing to stand up in court and say, I think this provision is constitutional, and nobody's willing to do that. Luckily, there are some folks in the House of Representatives who are excited to defend this, right? So these guys are excited to defend this, this provision is constitutional, and so there's an organization, you'll see if you look at the case, called BLAG, right? A really catchy acronym, the Bipartisan Leadership and Advisory Group. So this is in the House of Representatives, and they were willing to defend this, this provision in court. And the big question in Windsor was not whether same-sex marriage was nice, good, helpful, or anything else, but whether this group, BLAG, had the right to defend this provision is constitutional in the Supreme Court. The majority decided they did, and then went ahead and looked at the merits of the case and decided that it was in fact unconstitutional. So the really big question, the first of the really big questions was whether anybody had the right to actually defend this in court or not. And just to be clear, there are two operative provisions in DOMA, the Defense of Marriage Act. The first is Section 3, which says that for federal law purposes, marriage has to be between one man and one woman. But there's a whole different section in DOMA that was unaffected by Windsor. And this other section, Section 2, says that each state does not have to recognize same-sex marriages from another state. So if you come to New York, but you're from a state that doesn't recognize same-sex marriage, you come to New York, you get married, you go home, presto changeo, you're not married again. Right? So that provision, we don't know yet whether that's constitutional. Well, maybe we do, but
Under the full faith and credit clause, that case is going to be coming up because under the Constitution, states usually don't have that option to ignore the validity of acts taken in one state, lawfully taken in one state. So
or
to be continued.
Correct. Or we'd have a very confusing country where you're married in one state, then you move to another, and you're no longer married. All right. So all this is still setting the stage and proving my point that we're not really talking about what we think we're talking about here. Some folks probably know, those in Dr. Salholz's class probably know, that there are generally 3 levels of review of the constitutionality under the Equal Protection Clause of a statute. Right? So the legislature acts, and if it doesn't implicate any protected group, you apply what's called rational basis scrutiny. And you have to show the legislature wasn't completely nuts. Right? That's the level of scrutiny for this kind of statute, just to make sure they weren't completely nuts. And that really is the standard. I'm not making that up. And at the other end of the extreme, if you're talking about a constitutionally protected group, vulnerable group, race, for example, you apply heightened scrutiny. So there, it's a lot easier to strike down legislative action. It's not a question of whether they were just making sense, but whether they met a higher standard. There's also a third level, intermediate scrutiny, and as it sounds, it's somewhere between the two, and we weren't quite sure which of these standards were going to be applied in reviewing Section 3 to determine whether same-sex couples could be denied these benefits. So this was the other big question that we thought was going to be answered by Windsor, which of course means they didn't. Right? It's a little bit like, I don't know if you guys ever saw Who Killed Rosie Larson? Right at the end of the first season, you realized you weren't going to find out. I'm sorry if I ruined that for anybody. You weren't going to find out who actually killed her. You didn't find out which level of scrutiny would apply to this kind of case because they decided in a totally different way. What they decided was that Section 3 was motivated by animus. Right? So they said Congress, when it passed the statute, had nothing in mind other than being mean and nasty to same-sex couples. Maybe true, maybe not, but they didn't do what everybody thought they were going to do, which was tell us which level of scrutiny would apply and then apply it. They did something very different. Kennedy wrote the opinion, and it was, as is usual, he's a very smart guy, stupid thing to say about Supreme Court justice, but it was a very cagey thing to do because he wanted this opinion only to apply to Section 3. Right? He didn't want this opinion to be used against Section 2. He wanted it only to apply to Section 3, and he also didn't want this opinion to be applied against Section 2 indirectly by challenging the state laws that prohibit the recognition of same-sex marriages from another state. Right? So, so we decided they had standing. BLAG, had standing to challenge, to support the constitutionality of this provision in court. They reached the merits. They didn't do what they thought they were going to do. They didn't decide which level of scrutiny would apply. They just said it was motivated by animus. They looked at some of the legislative history, some of the records of what Congress did as they were considering it, and found a few snippets that said, boy, we sure don't like gay people, right? Which, of course, you can find Congress people saying about anything, certainly that. So they found that and ruled that Section 3 was unconstitutional. And we get to the question that Windsor raised, right? Is the transfer between Spire and Windsor, is it going to be taxed, or is it not going to be taxed in the same way that it would not be taxed for an opposite-sex married couple? And on that point, they did give us a straight answer, and it was that it was not taxed. So this was very good news. That was very good news. And I'll just make one more point. It was good news, but it's not always good news to be married for tax purposes. So it's not always good news to be married for tax purposes. And I'll just illustrate why. There were, not really why, but an example of it. I heard about these two folks, lawyers in the city who got married. They actually held a fake wedding for their family and friends, not telling them, and got married the next year. Why would you do this? Terrible idea. You should never do this. They did it, though, because when you both have a fairly high salary and a similar salary, you pay what's called the marriage penalty under the income tax laws. So what they did, they sort of subsidized their own wedding by holding a fake wedding one year, not getting married until the next legally, and using the tax savings to help pay for their wedding. Of course, if anybody ever finds out about this, and I tell everybody I can because I think it's hilarious, it's not going to be nearly worth it. Anyway, so I've rambled on for, I think, long enough.
That's great, because you sort of answered my second question.
Great.
Which was explain the constitutional basis, which I think that you did, that they looked at it. Should we say equal protection? I don't know if we can.
Yes, absolutely.
I just finished talking about equal protection to my
absolutely.
class this morning, so I wanted to get that out
Yep,
there.
no, that's right.
It was on the Equal Protection Clause of the 14th Amendment, but they didn't do one of the 3 tests of judicial review. I'm doing sort of some of the phraseology
Great.
that they can relate to.
Absolutely.
They had this other test, which we didn't go over because it's a non-traditional test. Of
Very delicately put.
To see what's going to, because they did not want to establish the test that would be applied to questions based on sexual identification as compared to race, religion, and all that other good stuff. And you also answered the second part of my second question, which was, what are the practical consequences of the decision?
Just to make this clear, I'll give you another example. Why don't I start with the good news? I'll start with the good news. The good news is that generally, if you're married, you will pay less tax if one spouse earns more than the other. You get married. The year in which you get married, your total tax burden falls. It's wacky, but it's true. It's a combination of the way we treat married couples and the progressive rate system we have. So you pay a higher percentage of your tax on the income you earn at higher levels. You put these two fairly benign aspects of our tax system together, and all of a sudden, in the traditional context, with one spouse earning more than another, you get what's called a marriage bonus. So you save money. But as I mentioned a second ago, there's also the possibility, if you have 2 spouses with similar incomes, of the marriage penalty. This is all kind of abstract and confusing to my federal income tax students, so I'll use a simpler example that I use sometimes with them. So there's a federal adoption credit. So if you adopt someone, if you adopt a child, the federal government has said, this is something we want to help support. There are costs associated with adoption. We want those costs to be not quite as burdensome as they might otherwise be, so we're going to provide a federal credit, a tax credit, for adoption. And there's an exception for that if you adopt the child of your spouse. Right? So if you adopt the child of your spouse, no credit, because the Congress didn't think this is something they needed to subsidize. You were going to do this whether or not they intervened. This wasn't quite what they had in mind. They had in mind you adopt someone from outside your family. So this is a different case. So you can see where I'm headed. If for federal purposes, including federal tax law purposes, same-sex couples are not treated as spouses, you get the credit if you adopt your same-sex spouse's child. If, after June, you adopt your same-sex spouse's child, no credit. So, it's a mixed bag, and it's important to understand that the tax treatment of same-sex couples is still complicated after Windsor. It is still complicated after Windsor. There's certainly jurisdictions that aren't going to recognize same-sex marriages. So if you live in a jurisdiction that does not, you come to New York, you get married, you move back to state X that doesn't recognize same-sex marriages. You have to file you may have to file your state returns as an unmarried couple, and then prepare another return that treats you as married couples for state purposes, and use that to file your federal return. Very complicated.
Can I follow up on that? Because I think there's one thing that is in there, just to clarify what Windsor did and didn't do. As Professor Dean said, it certainly didn't make same-sex marriage legal, but if two people are married because they were lawfully married in a certain state, or in this case, in another country, but then they were in New York, and New York recognized the validity of the marriage where it was celebrated, so that in the state they lived in, they were considered to be married. In that limited circumstance, under the case of Windsor versus United States, you get entitled to the federal estate tax exemption for married couples.
You get the estate tax exemption, and along with that, you
get
denied.
We're going to go into everything, and the income tax and everything else. But if you get married, if you're not married in a state that recognizes marriage, you don't get. It all goes back to whether or not the state accepts it.
So
Federally, for my students.
Absolutely, another. And just to explain, so the IRS always wanted to bring clarity where they can. I mean that, but they don't always. They tried to. They issued what's called a revenue ruling, which is their way of making official pronouncements on policy without going through Congress or anything like that. It's fairly informal, but it is their official position. They treat themselves as bound by these revenue rulings. They explained how they were going to treat same-sex couples, because this really leaves a lot unknown. I mean, aside from the bigger questions of the legality of same-sex marriage, even just on the limited question of how you tax same-sex married couples, it leaves a lot unknown. So what they did was they drew an analogy to common law marriages. So there are certain states that recognize common law marriages and certain states that don't. Yeah, so if you live together for that long,
good. That's what it is.
Absolutely, you're married even though you never had an actual celebration. So a little bit of a confusing turn of phrase, they apply the state of separation rule to common law, right? Celebration, but that's what they call it. If you are common law married in state A, and then you move to state B, they treat you as married even if state B doesn't recognize common law marriages, right? So they did this is true years ago, and they found this, were very excited, dusted it off, and said, we're going to do that, right? We're going to do that for same-sex married couples. We're going to look at the state where you celebrated your marriage, and if they treat it as legal, even if you then move back to another state that does not recognize same-sex marriage, but you can imagine how complicated it would be. For example, there are rules in the tax law that treat related people differently, and I won't horrify you with the details of those rules, but your tax treatment would change as you moved. And you'd be treated as unrelated in one state and related in another, a mess. You think it's complicated now, imagine how complicated it would be then. So the IRS actually issued this official pronouncement about what the law is for same-sex couples, which is really quite helpful.
I'm going to move on a little bit. I want to ask one more question about Edie, and then we're going to get to non-tax territory with Hollingsworth.
Uh-oh.
Yes, I know. So the last question is, as you noted, Edie brought her case specifically to contest the federal estate tax that was imposed on her wife's estate, and the case did have the effect of ending the same-sex marriage tax penalty. Can you describe any other changes in federal law that
I want to disagree. I wanted to on one point. So, and this again goes to the incredible subtlety of what Kennedy did in his opinion. he didn't say that they couldn't discriminate, right? He didn't apply one of the three levels of scrutiny, saying you can't discriminate. What he said, this is all they said. All he said was, I looked at the records of what Congress said when they were passing Section 3, and they meant Section 3 to hurt people, and you can't do that. So in a way, you could read this and say, that's great. So as long as we behave ourselves while we're passing the statute, we can discriminate against same-sex couples. So
okay, so it wasn't discrimination, but you cannot treat lawfully married couples differently for other purposes. It wasn't limited to.
Oh yeah. So all right. So all it said was this Section 3.
Change.
Right. This Section 3 that said you can't do this was unconstitutional. So if they want to discriminate, they need a new section, which they're happy to do, I'm sure.
So what other areas of
So it's incredible. So I would encourage people to take a look at the opinion, not only because it really is a wonderful way of getting an insight into how the Supreme Court works. It's both wonderful and terrifying all at the same time. It's just everything. So there are laws making it a crime to harm certain federal officials, sort of elevating the level of the crime. And now that those additional penalties for harming that kind of federal official are going to apply to same-sex partners of those federal officials. So it's incredibly broad. It's every federal law that imposes special benefits or protections or obligations on married couples now applies to same-sex couples as well.
It's like the privilege against spousal testimony in federal court.
Everything.
Everything. So
Everything.
Things that were not available, you would be in contempt of court. If you refuse now, you would be able to take the benefit of that. So the list goes on and on.
And it's a double-edged sword in almost every of those situations. So it's good news. I mean, in a lot of ways, it's just there's nothing but good news here. But the specific legal obligations and benefits that it endows on same-sex couples are not always great. The only ruling that really said anything, what it said was the Windsor case that said that in this specific set of facts, Section 3 of DOMA was designed to harm same-sex couples. So I don't know whether the fact that I don't know whether it matters that they wouldn't have, I can't imagine they would have mentioned trans couples in the legislative history, so one could imagine that it might not. On the other hand, it did strike down Section 3 entirely, so I think that would work, apply just as well. I don't think that it lives on for everybody other than those named in the legislative history. So I think it would. You can't pass a law that is designed just to harm a specific segment of the population. And so you can't say, this law is designed to make people named Steve feel bad. If you say that in the legislative history, you're going to lose. So why would anybody say that? Well, Congress people really can't help themselves. They say a lot of things they probably shouldn't say. Thankfully, in this case, so the test is really quite as simple as that. And the reason it's kind of obscure is that nobody's that stupid, really, usually. They don't say, boy, we're passing this law to harm people. You can always, any recent legislator or lawyer, for that matter, could always come up with a reason for an innocuous standing or even positive standing rationale for just the most pernicious statute. The Supreme Court managed to find a few snippets of legislative history that said something nasty, and they relied on that, and that's really it. They just said, listen, this was passed for these purposes. And one of the things that Scalia, and again, I always find it odd when I say, yeah, you're right, Scalia, but in his dissent on Windsor, one of the things he pointed out was that you can always find provisions that are animus-driven in legislative history if you look hard enough, or you often can. And what he imagined was another court looking at the state law, state rules, either constitutional or statutes, that prevent the recognition of out-of-state same-sex marriages, and looking in the legislative history or the constitutional history of those provisions and finding, some legislator who couldn't keep his mouth shut, saying how excited he was, or she was, that this was going to make same-sex couples feel bad. And if you can find that, Scalia says, and he's right to an extent, you can use the same animus test to strike down those bans on recognizing out-of-state same-sex marriages.
I want to thank Professor Dean for giving us the information, and as a good law professor should, raising many more questions than giving you answers, something to think about. And I thank you very much.